Good afternoon, everybody. Welcome back to another Impact and Influence series with Regrowth. Today, I'm really excited because we've got two partners from Swaab with us. Swaab are our law firm in Sydney that we do a lot of work with, particularly around merger and acquisition, industrial relations, and some commercial litigation. Julie Briscoe and Michael Byrnes, welcome to Impact and Influence.
Hi, Carly.
Thank you, Carly Walsh.
Thank you so much for joining us. We are getting a very good growing audience into this now. I think our last one, we had over 11,000 people download and listen to the interview, which is fantastic. So for anybody on our database that is thinking about succession planning, they're looking at resources and process internally for HR. We're looking at buying a rent roll or selling a rent roll. You're going to love this interview today. These two individuals come with a fabulous background, but I'm going to let them introduce themselves today because it is so vast. So, Michael, if we could start with you, could you let us know what you specialise in and what your background has been in law, please?
Sure. So I'm an employment lawyer, a workplace relations lawyer. I do both front-end and back-end work. That means that I draft employment contracts, I advise on employment law issues, but also do the litigation at the end, either before the Fair Work Commission or one of the federal courts or Supreme or district courts that employment law comes before. I both do that as an advocate and I sometimes brief counsel as well to conduct that litigation. And I cover discrimination, work health and safety, employment issues arising from mergers and acquisitions, unfair dismissal, general protections, the whole gamut really of employment and workplace relations law issues. I started working for a large law firm in 1996. Soon after I graduated, I worked for a Supreme Court judge for a year, as you do, as a tip staff to a Supreme Court judge, then worked for a large national law firm from 1996 until just before 2018, when I joined Swaab in 2018, and I've been here since.
So, Michael, no wonder that you are published frequently, and I'm going to ask you a question about an article after we hear from Julie's background that you published 6 days ago around right to disconnect, which I think will be of interest to a lot of our listeners. So look, thank you so much for giving us your time. Julie Briscoe, a face that is not going to be of a stranger alert to any of our listeners or our clients at REGROWTH. We've been working with Julie for a very long time. In fact, Julie was our company lawyer when I was one of the partners at Dye Jones Real Estate, and does a fabulous job with a lot of our clients around merger and acquisition. Julie Briscoe, what's your backstory?
Well, Carly, a very long career, over 30 years as a lawyer, still practicing, as we say. I started in smaller law firms, so I was more of a general person. But my specialties have always been in the area of commercial law and property law and all those associated things. So some leasing, some generally advising people on their businesses, doing shareholder agreements, partnerships, a bit of dispute work, but I'm more the front end, buying and selling of businesses. And so I joined Swaab 3 years ago now, and the thing I love about Swaab is that we have people like Michael who specialise in a very, incredible area like employment law, where we really need to drill down when there are issues. We have a very big property team, a big planning team, estate planning team, litigation team, family law team, and I love that we've got now so much expertise. We've got 90 people in the firm at the moment, and about approximately 50 of those are lawyers. So that's my background. What I work in a lot, and I have worked a lot in real estate over the years, but more so since the good people of REGROWTH have introduced me to so many people. Hopefully some are listening today. And as a result, I do a lot of rent roll acquisition and disposals, mostly acquisitions. And a lot of work with business owners of real estate agencies in their shareholder arrangements, or bringing smaller shareholders in, that sort of work. So it's fantastic. And I have a really good relationship with REGROWTH as a result.
So I think what we love working with you guys at Swaab is, some of our clients have got a bit more complex structures, and having that area of specialisation is incredibly important. Michael and Julie both come in and speak at our Elevating Leadership program and our Merger and Acquisition program that we do in-house at their offices in Sydney. And I think I continue to learn and evolve every time that I hear something from both of you when you come in as well. So I think while we're in that sweet spot of merger and acquisition, if that's okay, is I might just ask you a question about that, if that's okay, with disposal of business. Is Michael, something that comes up all the time, particularly in our industry, is restraint. And I think sometimes as real estate agents, we have a very creative definition of what that means and doesn't mean. What commonly do you see as people's interpretation? Where can it go wrong? And what sort, I guess, handy hints would you give to people around that? And I know it's quite a broad topic. So if
sure, it's a very broad topic. I could take up the rest of the session on that if you allowed me, but I'll give you a very high level précis. So one thing people assume or think is that restraints are not worth the paper they're written on, that they're of no value, they're automatically void. That isn't the case. There is a role for post-employment restraints, and a court will uphold a restraint to the extent necessary to protect the legitimate business interests of the former employer. And those legitimate business interests are usually confidential information and client connection, confidential information and client connection. So courts will uphold the validity of restraints, at least for what is necessary to protect those legitimate business interests. Of course, what an employer needs to do is to carefully craft the restraint. So this is the second lesson. The first lesson is they're not all void. They can have some validity. That's the first lesson. The second lesson is you need to carefully craft the restraint. So, for instance, if you're a real estate business and you operate within a 5-kilometre radius, don't seek to impose a radius of 100 kilometres on a former employee. That's just not going to fly. You need to think very carefully about what are your legitimate business interests and carefully crafting a clause to protect them. So that's very important. And also think about the role of the person in your real estate business as well. Does the receptionist really need to have a post-employment restraint, or are you really going to enforce a restraint against, for instance, a receptionist who, while they might have a very important role, isn't right there on the coalface involved in selling with clients necessarily? So you need to tailor the restraints to the particular individuals involved as well. So there's some thoughts on restraints. It is a complex area. It's an area where businesses need to think very, very carefully about the scope of the restraint, drafting the restraint. Those who are subject to restraints don't just assume that it can't apply to you, it won't apply to you. I'm entitled to earn a living. There's no way it can apply to me. That isn't the case. But of course, restraints can be challenged, and they're successfully challenged when there isn't care taken in defining the scope of the restraint and carefully drafting the restraints. And of course, that's where lawyers do have an important role.
And can I just add to that, sorry, just with a business sale transaction, restraints in relation to the vendors, obviously they're of more importance or can be of more importance, and more wider restraints upheld in that situation because a person is paying a lot of money to buy that business. And so it's really important to craft very careful restraints around the sellers so that they are not then, starting to pinch your rent roll 10 minutes later and employing your staff, taking your staff. So that's very important in the area of merger and acquisitions.
And Julie, what are you commonly seeing out there at the moment? Because this has changed greatly, I feel, in the last 2 years as acceptable, or what are you commonly seeing?
Oh, Kylie, it's not, there's no answer to that because you have to look at each situation. If in the location, where are you? Are you in metropolitan Sydney? Are you in outer suburbs? Are you in the country? So it's really, it's not a question I can answer.
Okay.
Each one has to be looked at. I think Michael would agree.
Well, Michael, what I heard from you, which is really interesting in our industry, again,
My cat is howling, sorry.
That's okay. we tend to make things up in real estate around restraint, and then it becomes folklore. So it was two things that I picked up there for our listeners. One is the greater risk that an individual is, or the tenure potentially that you've had with your organisation, i.e. a high-performing sales agent or a property manager that's been there for 20 years, is that you probably need to come and seek someone like your guidance around that, because the risk when they go is much greater around intellectual property, data, and I suppose cascading restraint. Is that the word?
Yes, there are usually cascading restraints, which is a way of hedging your bets when it comes to enforceability. So in effect, you're saying, well, we want 6 months as a restraint, but if 6 months is unenforceable, we'll take 3, and if 3 is unenforceable, we'll have a month. So it's a way of hedging bets when drafting restraints. But to your point about position and seniority, the more senior you are, then the more access you have to confidential information and client information, and of course, usually the more contact you have with clients, with customers. And that means you can pose a greater risk to the business upon departure. And the law will recognise that by making it more likely a restraint can be enforced against those sorts of people in senior roles than more junior roles. Bearing in mind the purpose of the restraints is to protect the legitimate business interests of the former employer, those being usually confidential information, customer connections.
I suppose, Julie, that's where when you are buying a rent roll or selling a rent roll, asking the question around is who's got a standard employment agreement under the real estate award, who's got an executive contract, who's got a contractor arrangement, because no doubt what Michael's talking about will affect all of those things, and they become very, very important. Julie, curious with and we had a big influx before Christmas of people wanting to use your services around buying or selling rent rolls. And again, as to Michael's I guess wording around this, we could talk about this for an hour, but if you want to talk about it for an hour, everyone's just going to have to come to our next course. Is what are you seeing causes friction in contracts or settlement or post-settlement when people are buying or selling rent rolls? What would you commonly tell people to be aware of and keep in mind?
Well, obviously it's very important in contract drafting to work out, what properties you pay for and don't pay for. That's a really important thing, and having due diligence with conducted by people such as the REGROWTH team is really helpful. I've seen in the purchases I've been acting for. So it's a combination of, getting the right drafting of what is a lost management, what is a vacant property, what is a non-compliant property. But the issue still I'm finding at the end of a retention period is that people are taking that opportunity to still challenge, you lost this because you were no good. It's a really difficult area. It can cause people, you have to put a list together of why is this one and not something we should pay for. And then there can be arguments about whether or not it's borderline, it's a termination during the retention period. Why was it terminated? Is it going to come back on? Sometimes contracts are varied to deal with that. If it's something, we've had illegal granny flats, houses burning down, things that are completely unexpected. So you need to have that flexibility at the end of that period to know what to work out with the vendors, what you're paying for, what you're not paying for.
And Julie, can you protect yourself more and more around that with definitions?
Yes, as much as possible. But like I said, who knew an illegal granny flat was there in this rent roll the other day that I was asked about? You don't think of that sort of thing as being something that you would have, a property shouldn't be put out for management if it's an illegal property.
Oh, I think they need REGROWTH compliance checklist, Julie Briscoe. That's what
I think we learn every time. We learn one more thing to put in that list.
We do.
Yeah.
Michael, you were quoted recently, and I've just looked at the number of articles you published, and it's unbelievable. You were quoted about 6 days ago.
I do practice law as well. I just want to make
What about his radio
clear.
career, Kylie Walsh? He has an extensive radio career as well.
Golden tonsils too, Michael.
I don't know about that. There's no golden microphone here, but anyway.
So where do we tune in to listen? Tell us about that.
I'm occasionally on 2GB with John Stanley.
Okay, fantastic.
Kind
All
enough
right, well,
to
we
interview
might
me
put
from
some,
time to time.
we'll put some links in there to some of that as
Sure,
well as
yeah.
the articles
They're
that I
fun
think are,
segments to do. John's great to work with, and he's kind enough to have me on his show from time to time when there's an interesting issue that arises.
I think the thing I love about working with you and Julie is you dumb it down for us estate agents and put it in layman terms, but you both you get our sense of humour, and you've both got a wicked sense of humour, which is great, I think, when you've got a working with your profession. So thank you for that. But Michael, the disconnect bill, some people will be going, what does that mean? And what's recently come out? What is the right to disconnect, and what does it mean?
Well, recently, as part of a broader suite of industrial relations reforms, there's this right to disconnect that will be implemented in the next few months. And what it involves is an employee having a right to refuse to read, monitor, or respond to out-of-hours contact from either the employer or a third party connected to the work they do in their employment, which of course could be a client or a customer. And an employee has a right to refuse that contact, provided the refusal is not unreasonable. So a lot of media coverage on this has said, well, this means an employer simply cannot contact an employee out of hours. That's not right. It's not a prohibition. The proposition is not as simple as that. So if, for instance, you're a real estate agent, you're your principal, you want to contact one of your employees to say the listing tomorrow morning has been pulled, or the property's already sold, so we're not doing the open house tomorrow. You can absolutely contact an employee to say that. Some of the reporting around this has been hyperbolic or exaggerated, where it says an employer can't contact an employee at all. That just isn't right. But what the employee does have is a right to refuse contact, provided the refusal is not unreasonable. And what goes into determining, the factors that go into determining whether a refusal is unreasonable are things such as the reason for the contact. So where it's rescheduling or cancelling an open house, then clearly that's going to be a good reason, a compelling reason to contact your employee to say, don't show up at this house. The house has been taken off the market or sold, or the open house has been rescheduled, something like that. There are other factors as well, such as whether the employee is specifically paid to monitor for out-of-hours contact and then to respond to that contact, the nature of the employee's role and responsibilities, also the employee's family and carers' responsibilities. So a factor that's personal to the employee. These are the factors that go into determining, and that's not all of them, and the list that must be taken into account is a non-exhaustive list. But these are the factors that will be taken into account in determining whether an employee has a right to refuse contact out of hours, or whether they need to read and monitor, for instance, email messages or text messages from the employer or a client out of hours. One issue that I think could arise for the real estate industry is where you have a client selling, a vendor selling their property, or even a prospective buyer, and they ring an employed agent and they want to relay information, relay an offer to that agent out of hours. The agent looks at the phone and says, I'm not taking that. I've got my right to disconnect. Go away. And they either refuse to deal with it, or actually, perhaps even worse, say to the vendor or the prospective purchaser, I'm not dealing with you. This is out of hours. Go away. Now, on the face of it, on the right to disconnect, they might have that right. I think there's a real argument, given the nature of, say, a lawyer's role or a real estate agent's role, that you need to take calls out of hours on occasion and deal with them. And that's part of your role and responsibility. But nevertheless, it gives rise to an issue that probably does need to be managed certainly within our profession, the legal profession, for employed solicitors, but also for employed staff within the real estate industry, and what will be done when they invariably receive contact out of working hours from either vendors or purchasers who want to speak to the agent to relay some information or the like. And so it's something for those in the real estate industry to be aware of, and perhaps have in place expectations around communication with customers, with vendors, purchasers, and the like, so the issue can be actively managed and protocols for communication can be put in place and expectations established.
I think, Michael, the thing for us is we're probably lucky, I think, with our legislation and acting in the best interest of our customer from a sales point of view. But while you were talking about that, there was two things that came to my mind. First one was, I think it's quite easy to free up people's future in sales that don't respond to offers. That's the first thing. But the second thing is property management. So clearly defined, what is an urgent repair, but what's not an urgent repair, and wonder how that would be dealt with if a tenant reported, like I'm sitting here now and there's a massive storm going on, around me. Sure, a tree through a roof certainly constitutes it's not habitable, but what other repairs? And I think probably, from property management, from what you're saying, I see some really complex, scenarios for us in that space. And I don't think anybody has really thought about this. What are the timelines? What are they saying about the bill? What can we expect?
So for larger businesses, 6 months. It'll be 6 months after the act is enacted. And then after that, smaller businesses have a further 12 months before it's put into effect. So it's certainly something for businesses to think about and to plan for. One way perhaps of dealing with it is to have messages in your email or auto responses for text messages that, out of hours, unless something is urgent, then it won't be dealt with. Perhaps, although some would find that unpalatable from a sales perspective or from a service perspective. So it is going to be an interesting issue, and different businesses will take different approaches to addressing it. But I think where you've got real estate, as you say, property management, real estate sales, a lot of the action happens outside of what might be described as conventional working hours, or even the set working hours for professionals in that industry. And so this will become a live issue. And you're right, of course, Kylie, if I'm a vendor, I want to know that my agent is ready to take offers any time of the day or night, I'd imagine.
And the one word I'd say is commission. That's going to be your incentive.
That could be a driver, but bear in mind, it may well be you have a staff member who says, well, I'm only getting a small part of the commission on this. I'm relatively junior. I don't want to have to take this call now, and I have my right to disconnect. I'm not going to take it. It's going to be an educative piece, not only for employers, of course, but also employees, because some employees are going to look at the headline, right to disconnect, think it acts as an absolute prohibition, and they will unreasonably refuse contact from either the employer or a third party who is involved with their work in some way. So employees need to know it's not an absolute prohibition as well, and employers should be setting reasonable expectations consistent with the right to disconnect around the obligation on staff to monitor, read and respond to emails and text messages and the like, contact out of working hours.
I think I'm going to go straight into the weeds there, and I'm going to say straight away, we're going to give a lot of links around what Michael's published and the links that are available online. Secondly, though, for our listeners, this is a really good opportunity for you to talk to your tech partners and make sure that your auto chats, the offer templates that are out there, repairs and maintenance technology that's available, is probably a good time to adopt and consider the implications. Onboarding will need to be updated. And thirdly, I think everyone should be speaking to Michael about the impact and what they need to do to get their business ready. I'm really mindful that we've been on half an hour. So, Julie, I've just got 2 questions for you in closing, if that's okay. I know that it's a frustration, certainly of ours at REGROWTH, and I know that real estate agents would never cause you to be frustrated, Julie Briscoe. But how important is it in negotiations and preparing a contract that whenever people are thinking about succession, selling or buying, how soon should they speak to you, and why is that so important?
They should speak to both me and the accountant, and together we work as the team and also obviously the financier has to get involved if, to be able to afford to do what they're doing. But succession planning and structure has to be right from the beginning, and succession planning is very important as well. So how you, and particularly if you've got plans to grow, you know, substantially, you might have plans to buy, you know, 3 more rent rolls over the next 5 years. You need to work out how that is structured best. Who is going to be involved? Are you going to have different shareholdings in different businesses? If so, you know, have a really good shareholder agreement that you can adapt over the different businesses. And so we work very closely, particularly with the client's accountant, to make sure we understand, implement the structure that is the best recommendation from the tax and the planning point of view.
I think it's so funny. Stuart was texting me about a meeting this afternoon because Stu is an accountant that we work with. And I think so many people don't consider the end when they come in, you know, capital gains, selling in, other shareholders along the way, not doing a shareholder agreement, and
Correct.
then waiting until there's a dispute, and then there's no foundation of which to try and navigate or facilitate or mitigate, I suppose. So it is incredibly important. Julie, one last question to finish, if it's okay, and I really could speak to both of you all day, 2 incredibly talented people in this space, is what has surprised you, particularly in the real estate arena with respect to purchase or acquisition of rent roll, or shocked you?
There's a lot of shock.
And Julie's not easily shocked.
No, I'm not. Shocking more. I am constantly surprised by how much talent there is out there, and ambition, and you know, but I would just say to people, that's all very well to have all that drive and energy and want to grow, but do get advice from everyone, you know, how to do it best. And I think that we see more and more of that coming through, that people are properly planning how to do something. You know, it's not, you can't just step out on your own and start doing things without setting it up properly and planning for how it's going to work and how to get out again at the end.
Very interesting, isn't it? What, you know, what's the strategies at growth for the sake of growth? What's the investment in this project? And we see it all the time. You know, people are paying $6,500 to $12,000 in Sydney per management. But as soon as you get your quote from your lawyer, from REGROWTH, and your accountant, they're like, that's too much. We're like, hang on a second, what are you building here? What are you setting up? And then as soon as you start going through hemorrhage or leakage of what could look like by the end of the, you know, the restraint or the retention period, is it starts to become very believable. What I would say to anyone that is thinking about buying or selling a rent roll, or engaging with Julie or Michael, is have a look on our website for the events and training that we've got coming up in this space. There's not enough education around this in our industry, so educate. These are courses with specialists like this that you should do at least once every 5 years or once in your real estate career. But set yourself up for success and think about the end game now. Because we all work too hard to ripping up dollars and not protecting ourselves. And I think, Michael, I just want to finish on a funny story. So when you came into our last workshop and you were talking about the cascading restraints, I had not 1, not 2, but 5 principals come up to me say, we always thought when we were signing contracts with salespeople or property managers that you had to pick one, and we always cross out, you know, the 4-year or this year, and I'm like, oh, wow.
No, that's not the way it works. Do not do that. Don't do that.
That's what the judge does.
Exactly right, Julie. That's why that's what the judge's role is. The judge.
That is funny. I've seen a lot of those contracts. I thought that was a deliberate, you know, okay, we're going to give in on that one and just cross out 25Ks. There you go. That's something I've learnt today, Kylie Walsh.
You live and learn. So look, I just want to summarize it. We've covered a lot and we've got a million miles in 40 minutes. But I think, guys, please, this is not just a sell. I really want the industry to protect their asset and look after their rights. So please come along to the training. We'll put the links for Julie and Michael's details in the communication that we send out to the database. But Michael and Julie, thank you so much for giving us 40 minutes of your time today. As always, we always pick up and learn something, and we're grateful for the partnership.
It was a pleasure, Kylie. Thank you.
Thank you so much, Kylie. Always a pleasure.